To the League of Women Voters of Washington, interviews of candidates for Supreme Court Justice for the upcoming August primary. The League is a nonpartisan organization. We never support a party or a candidate. My name is Eileen McCracken, and my guest today is Theo Angelis, who is running for position 5 on the Washington State Supreme Court. We're asking all the candidates for this office the same 4 questions. Each candidate will have up to 90 seconds to answer, and the answers are timed. This video of candidate Angelis' responses will remain on our website until after the primary election, which is on Tuesday, August 4th. Candidate Angelis, thank you very much for agreeing to this interview and seeking to serve in public office. Our first question is, what are the benefits of being or not being a judge before running for the state Supreme Court?
I just want to repeat the question, make sure I had it.
I'm sorry,
Just a second there.
I had told you before it was a different question. What are the benefits of being or not being a judge before running for the state Supreme Court?
Great, thank you. So, great question. And, my predecessor, Justice Madsen, tells a little story that when she was about to retire, she went to the governor, Governor Ferguson, and said to him, Governor, there are a lot of perspectives in the room when we're deliberating on cases, but one of the perspectives that's missing is that of someone who has been in private practice their career for a long period of time and has done private practice at a very high level. She said there are a lot of former judges in the room and their perspectives are useful, but we need someone who has represented the leading companies in Washington and people and governments. And so that really is what we're missing. And I think the governor really took that to heart. So for me, it's been a real benefit to have had a very broad career where I've represented municipalities, individuals, leading technology companies from all over the world and from in our state. I've represented tribes. I've represented, people who are homeless and immigrants, but I've also represented a lot of individuals who have struggled with the legal system on their own. And so having a broad experience with individuals from across the spectrum and from our leading companies has allowed me to be a unique voice when we're deliberating and to bring perspectives as we're trying to reform our justice system that just aren't well known to a lot of the others who are there. And so I believe it's been a huge benefit not to have a long judicial experience, but instead to have been in private practice for so many years.
Thank you. Question number 2, how would you approach a case in an area of law with which you have no knowledge or experience?
So this does come up from time to time. Again, it's sort of the flip side of my very long experience in private practice is that, for example, I don't have a lot of experience in criminal sentencing. And we had a series of important cases this last term we heard that dealt with the question of what kinds of facts relevant to sentencing can be found by the judge and what facts need to be found by the jury. And this was an area that was relatively new to me. I certainly had studied Apprendi, which is one of the leading federal cases and other cases in the area, but there are some unique nuances of Washington sentencing law regarding what we call washout or same criminal conduct that I needed to learn. And so what I do is I go back to school. I get very aggressive in spending hundreds of hours just not only reading all the briefs and the record in our case, but making sure that I understand the legal framework. And so for me, I spend Tuesdays through Thursdays in Olympia. My family's in Seattle. And when I'm there, I'm just in chambers, wandering around late at night, reading all of the key cases, sometimes pulling old books off the shelves, when I'm all alone in chambers. And so I just totally dedicate myself to learning that area of the law backward and forward. And then I come to conference extremely well prepared. And that's how I handle new areas of the law for me.
Thank you. Third question, when is it appropriate for the judiciary to overturn a statute or popular referendum?
So this is an area where we as judicial officers have to tread very lightly. So we understand that separation of powers depends on recognition that we are not policymaking branches, with very limited exceptions. We certainly run policy for the judicial branch as a whole, and we have important common law responsibilities, but generally speaking, we defer to the legislature and to the people as they've enacted our Constitution and laws indirectly and directly through initiative and referendum They're the ones who make policy. So for us, we have to defer to those policy judgments as best as we can understand them. And we want to always interpret the law in a way that is faithful to what the legislature has done and is as workable as possible. In that vein, we want to make sure that the rules we set down are something that lower courts and prosecutors and defense lawyers can actually implement. So those are all really important. But generally speaking, we need to police our power, our judicial power, but ensure that we defer to the policymaking power of the other branches of government.
Thank you. And our last question today, is there a judge or justice in history or today that you most admire and why?
So the justice that I most admire is Thurgood Marshall. And in some ways, that's a very easy thing to say. Of course, Thurgood Marshall, civil rights icon, amazing Supreme Court justice. But what a lot of people don't remember or don't know is that he was a brilliant litigator. A few others created a strategy that the NAACP Legal Defense Fund implemented that was designed to bring cases that were clearly so clearly needed to be overturned that even segregationist judges, even judges that were hostile to what was trying to be accomplished, couldn't help but blanch at some of the practices that were being practiced in the United States, both in the Deep South and elsewhere. And so those cases, one by one, started to fall. Those precedents that were utterly indefensible started to fall. And he built a unified strategy around getting to genuine civil rights and actual civil rights. And so it was careful, it was methodical, it was brilliant, and it was great advocacy that was done often while he was stuck in a jail cell after being held in contempt or otherwise not being allowed to avail himself of ordinary accommodations in the cities where he was visiting. So truly, truly impressive legal work that led to a brilliant legal and judicial career.
Thank you. And once again, thank you for giving the public this insight into your views and values. Viewers, please don't forget to vote by August 4th. A voter may return a ballot in person at the auditor's office or deposit it in one of the officially permanently installed ballot drop boxes located throughout the state. Ballots sent by mail must be postmarked by August 4th. To ensure a ballot receives a timely postmark, a voter may hand it directly to a postal clerk inside the local post office and request a hand-applied postmark at the counter. When in doubt, always use a drop box. A complete list of drop box locations is included in your voter pamphlet or at votewa.gov. Thank you.